Welcome to the University of Michigan Senate's 23rd Annual Davis Markert Nickerson Lecture on Academic and Intellectual Freedom. This lecture was held on October 23, 2013 in the Honigman Auditorium of the University of Michigan Law School in Ann Arbor, Michigan. The lecturer was Marjorie Hines, founding director of the Free Expression Policy Project. The title of her lecture was Priests of Our Democracy, the Supreme Court, Academic Freedom, and the Anti-Communist Purge. Introductory comments were made by Graham Rex Holland, professor of dentistry at the University of Michigan Dental School and vice chair of the Senate Advisory Committee on University Affairs.
My name's Rex Holland. I'm the Vice Chair of the Faculty Senate and Senate Assembly Committee on University Affairs. And as this is formally a meeting of the University Senate, I would like to call the meeting to order. We're here to listen to the 23rd Annual Davis Markert Nickerson Lecture on Academic and Intellectual Freedom, something which marks important events in the history of this university. The first and hopefully the only item of business I need to participate in is to introduce the president of the Academic Lecture Fund, Peggy Hollingsworth. Probably needs no introduction to many, if not most of you. Peggy was the chair of SACUA and the Senate in the early 90s when this lectureship was established. She's now emeritus, but has had a long career, notable not only for her scholarly research and her contributions to both the university and the community at large, and in particular to faculty governance. She was the second woman to be elected chair of the Faculty Senate. Her contributions in governance and service have been recognized with a number of awards, including the University of Michigan Distinguished Faculty Governance Award in 1994 and the Jackie Lawson Memorial Faculty Governance Award in 2007, which recognizes her efforts to promote, through good faculty governance, the missions of the University of Michigan on its 3 campuses. In 1990, the Senate Assembly set up the Academic Freedom Lecture Fund to support the annual lecture series and the events related to it. Peggy has been the president of the Academic Freedom Lecture Fund since that time and has worked with a group of distinguished, active, and retired faculty members and others, both nationally and internationally, to raise the funds necessary to perpetuate this lectureship. President of the fund serves with the chair of the Faculty Senate and the president of the Ann Arbor chapter of the American Association of University Professors on a little committee that selects the annual Davis Markert Nickerson Lecturer. Peggy's energy and dedication to nurturing this event over the past decades is really remarkable. And it's my great honor and pleasure to introduce Peggy Hollingsworth to you.
Good afternoon. Welcome to the 23rd Annual University of Michigan Senate's Davis Markert Nickerson Lecture on Academic and Intellectual Freedom. Each year for the past 22 years, a distinguished scholar has addressed us on a topic of great interest and vital concern to the academic community and indeed society as a whole. The Senate Assembly's Davis Markert Nickerson Lecturer Selection Committee was extremely pleased when Marjorie Hines, founding director of the Free Expression Policy Project, accepted this invitation to deliver the 2013 Davis Markert Nickerson Lecture. In her award-winning book, The Priests of Our Democracy, she cites 2 University of Washington professors from the McCarthy era. Edwin Harold Eby, who said, quote, "If I was going to make a living in the U.S., I had to shut up. That was part of the job," end quote. And Melville Jacobs, who wrote that, quote, "Throughout the remainder of his teaching career, he would not sign anything even remotely political, end quote. Such self-censorship, which is the theme of Marjorie Hines' book, is a kind of censorship that is all too common on our campuses today. Two recent cases in the state of Michigan that obviously would instill fear in the professoriate are those of David M. Halperin, W.H. Auden, Distinguished University Professor of History and Theory of Sexuality, whose University of Michigan English 317 course, How to Be Gay, Male Homosexuality and Initiation, several years ago led politicians in Lansing to propose a bill that would allow the legislature to veto course offerings at the state's public universities. And William Penn, a Michigan State University Native American creative writing professor who was pulled from the classroom at the beginning of the current term for making comments critical of one of the major political parties. As I have mentioned in previous years, today we desperately need Americans of all ages who will join the battle to preserve the academic and intellectual freedom guaranteed by the First Amendment of the United States Constitution. Needed are citizens with the enormous courage that was demonstrated by Professor H. Chandler Davis when in November 1953 he stood before a subcommittee of the House Un-American Activities Committee and claimed his First Amendment rights. Professor Davis is one of 3 former faculty members after whom this lecture series is named. He is here with us today as he has been here every year since the first Davis Markert Nickerson lecture. Chandler, will you please stand so that we can recognize you? This year we lost 2 very important members of our community. Marjorie Jackson, Associate Professor Emerita of Nursing, passed away on September the 5th, 2013. She was for many years a member of the Board of Directors of the Academic Freedom Lecture Fund and a major contributor to the fund. Edward Shetikoff, Professor Emeritus of Music, passed away February the 12th, 2013. We're fortunate to have today his wife Rebecca and his sister Harriet. Thank you so much for coming. He had been dedicated to the protection and promotion of academic freedom and shared governance since he was appointed to his first faculty position in 1959 as an assistant professor of music at Oberlin College. He had a key role in the establishment of the Davis Markert Nickerson Lecture Series, and for the past 10 years served as chair of the Academic Freedom Lecture Fund Investment Committee. Please join me in observing a moment of silence in their memory. Thank you very much. I would be remiss were I not to thank those who not only have made these lectures possible, but who also have made them so successful. The University of Michigan Faculty Senate Assembly adopted the resolution that established the series. The American Association of University Professors, AAUP, provided a grant to support the first lecture with a proviso that our faculty matched that grant. And the directors and members of the Academic Freedom Lecture Fund over the years have ardently supported the cause of academic and intellectual freedom and have given whatever they could afford to sustain and promote the series. In addition, again this year, a contribution for the lecture series was included in the philanthropy of an anonymous donor. Some academic and administrative units of the University of Michigan today provide support both in money and in space for the lecture series, as well as the organization and groups listed in your program. We greatly appreciate the efforts of Carol Jacobson, Professor of Art in the Penny Stamps School of Art and Design and Professor of Women's Studies in the College of Literature, Science, and the Arts, who was instrumental in bringing together members of our academic community interested in the work of our speaker. Professor of Law Margot Schlanger arranged with Derek Daylock, a University of Michigan law student and officer in the National Lawyers Guild, for our Professor Hines to meet with a member of the National Lawyers Guild. The advisory board of the Academic Freedom Lecture Fund and the past Davis Markert Nickerson lecturers have had a key role in the recruitment of the distinguished scholars who deliver the annual lecture, including our speaker today, who was suggested by Nadine Strossen, who presented the 2007 Davis Markert Nickerson lecture. We have the good fortune, again, to have with us today Jared Wadley, Senior Public Relations Specialist, who for the past 5 years has written excellent articles about this annual lecture for the University Record. As he has done in many years in the past, Sean Deloche, law school media consultant, has worked with Edward Hamlin, videographer, and this year, Jeremy Devlin from Michigan Media to record the lectures so it can be seen by those who cannot be with us today. Finally, the staff of the Faculty Senate Office, Thomas Schneider, and especially Linda Carr with the students who work in the Faculty Senate Office provide the necessary staff and logistical support. We must thank Linda Carr, who is retiring from the university this coming Friday, for her unstinting efforts to sustain the lecture series during the past 7 years. It has been my privilege and pleasure to work with Linda over a period of many years. She will be greatly missed. Linda, would you please stand? Thank you. Also with us today is Robin Schneider, who is sitting beside Linda, who will be taking over for Linda. Robin, we look forward to working with you. This year, the student who assisted us was Carrie Wolosky. Carrie, I hope I'm not destroying your name. Master student in the School of Public Health, Department of Health Behavior and Health Education. Just to remind you, there will be a book signing immediately after the lecture. I would like to thank Gail Townsend, Customer Relations Manager at Barnes & Noble of the Huron Village, who has today brought copies of Professor Hines' most recent book for us. It's an excellent book, and it'll be a wonderful addition to your library. And now, University of Michigan Provost and Executive Vice President for Academic Affairs, Martha Pollack, will introduce this year's University of Michigan Senate's Davis Markert Nickerson Lecture on Academic and Intellectual Freedom. Thank you very much.
Thank you, Peggy. Good afternoon. Since it began in 1991, the Davis Markert Nickerson Academic and Intellectual Freedom Lecture has become an important annual event, bringing to campus distinguished scholars, jurists, and journalists to speak on the fundamental issue of academic freedom. The lecture is named for 3 former University of Michigan faculty who took a stand in support of intellectual freedom. In the early 1950s, at the height of the McCarthy era, the United States House of Representatives Un-American Activities Committee sent a delegation to several states, including Michigan, to collect testimony about possible subversive activity. Professors Chandler Davis, Clement Markert, and Mark Nickerson were called to testify, but they refused to do so. As a result, Professor Davis was dismissed from the university and was also charged with contempt of Congress. He was indicted and then in 1957 convicted on the contempt charge. After an unsuccessful appeal, he was sentenced to time in federal prison. After leaving prison, Professor Davis joined the faculty of the University of Toronto, where he has had a long and distinguished career as a mathematician. Professor Markert, a biologist, was also suspended from the university, but ultimately reinstated in his position in biology here. Nevertheless, he left Michigan to chair the Department of Biology at Yale. Elected to the National Academy of Sciences, Professor Markert finished his career as a distinguished university research professor at North Carolina State University. Professor Nickerson was dismissed from the university despite holding tenure here. A pharmacologist, he took a faculty position at McGill University, where he led the department, authored more than 250 publications, and later served as president of the Pharmacological Society of Canada. The Davis Markert Nickerson Lecture honors these 3 former University of Michigan professors for defending the fundamental rights of freedom of thought, of speech, and of political activity. And we are also so proud that they went on to have such successful academic careers. The importance of these rights of freedom of thought, speech, and political activity was affirmed again by our Senate Assembly when it adopted a statement on academic freedom in 2010. Today, we are honored to have Marjorie Hines here with us as the Davis Markert Nickerson Lecture. A civil liberties lawyer, author, and teacher, Ms. Hines has focused on questions of intellectual and artistic freedom for more than 3 decades. After graduating from Cornell University, Ms. Hines was a journalist and anti-war activist in the San Francisco area. She went on to receive her law degree from Harvard and then began a career that has included service in the Massachusetts Attorney General's office, where she was chief of the Civil Rights Division, and with the ACLU, where she focused on censorship in the arts. In 2000, Ms. Hines founded the Free Expression Project, which is dedicated to exploring and addressing challenges to free expression from censorship, media regulation, and intellectual property laws. She is the author of several books, including the recently published Priests of Our Democracy, The Supreme Court, Academic Freedom, and the Anti-Communist Purge. She is also an adjunct faculty member at New York University. Please join me in welcoming Marjorie Hines.
Thank you, everybody. I'm deeply honored to be giving this year's Academic Freedom Lecture, especially considering the formidable qualifications of some of my distinguished predecessors. Nadine Strawson has already been mentioned. She was my sort of boss when I was a First Amendment lawyer at the ACLU, and she was the president of the organization. It was during my time at the ACLU that I really began to think about academic freedom, and that my book, Priests of Our Democracy, began to take shape. In those days, I dealt with countless controversies that touched on campus free speech, from students relegated to obscure and distant free speech zones for their protests, to professors forced to remove classic nudes from classroom walls on grounds of possible sexual harassment. In the last case I worked on, the ACLU represented 6 professors who objected to a Virginia law barring them from accessing anything sexually explicit on their office computers. It seemed like a slam dunk academic freedom case. The ban presumably included literature by D.H. Lawrence, James Joyce, or Algernon Charles Swinburne, a 19th century poet of somewhat kinky sexual tastes. It presumably included psychological texts by anyone from Seder Masek to Kinsey to Dr. Ruth, not to mention much other legitimate grist for the academic mill. As it happened, we won that case, but not for long. The state of Virginia appealed, and a conservative majority of judges on the Federal Court of Appeals for the Fourth Circuit ruled that professors don't have any First Amendment protection for their job-related research and writing and teaching. How did this bizarre and still much contested ruling come about? That's part of the story I will tell you in this lecture, so stay tuned. What I'd like to do today is first give you perhaps the shortest ever summary of how the Supreme Court came to recognize a First Amendment right to academic freedom in response, admittedly rather belated response, to the anti-communist investigations that afflicted education and virtually every other aspect of American life during what we call, in shorthand, the McCarthy era. Then acquaint you, also necessarily briefly, with a few of the interesting characters I met in the course of my research, sometimes in person, sometimes by reading about them in library archives. Then I'd like to give you an also necessarily brief overview of some of the conflicts and ambiguities that afflict the doctrine of academic freedom today. And finally, I'll describe 3 recent controversies, what I call my not-so-hypothetical hypotheticals, that make us think more deeply about what academic freedom means as a matter of both First Amendment right and educational policy. That is, what are its scope and limits? So, on to part 1. The Supreme Court discovers academic freedom. In all the cases I worked on at the ACLU that touched on teaching, scholarship, or campus free speech, I would cite the stirring language in Supreme Court decisions from the late 1950s and the 60s, in particular 2 cases that recognized the harm to intellectual freedom caused by the investigations and purges of the McCarthy period, which engulfed, among hundreds of other victims, the 3 scholars for whom this lecture is named. The first case was a 1957 decision called Sweezy versus New Hampshire. Professor Paul Sweezy was charged with the crime of contempt for refusing to answer a few intrusive and overly simplistic questions put by the Attorney General of New Hampshire about his knowledge of people working in the Progressive Party and about the content of a lecture he had given at the State University. Because the Attorney General's scope of investigative authority was so broad and vague, the Supreme Court reversed Sweezy's conviction on due process grounds. But in the course of the opinion for the court, Chief Justice Earl Warren wrote, and this language may be familiar to many of you, quote, the essentiality of freedom in the community of American universities is almost self-evident. No one should underestimate the the vital role in a democracy that is played by those who guide and train our youth. To impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. Teachers and students must always remain free to inquire, to study and evaluate, to gain new maturity and understanding. Otherwise, our civilization will stagnate and die. End quote. The other great academic freedom case I love to quote was Nickerson versus Board of Regents in 1967. By this time, the anti-communist fervor of the 50s had receded sufficiently for Justice William Brennan to pull together a 5-4 majority, so even in 67, it was very tight. But Nickerson is important not just because the decision disapproved of the excesses of a particular investigation or chipped away around the edges of a loyalty program, but this was the case that actually invalidated the basic mechanisms of the heresy hunt. Guilt by association with the Communist Party or any other group considered subversive, and punishment through loss of employment for advocating or publishing vaguely defined categories of seditious or revolutionary ideas. And because the law challenged in Nickerson applied to teachers, Justice Brennan unleashed some powerful rhetoric about academic freedom, which he said, quote, is of transcendent value to all of us and not merely the teachers concerned, and therefore is a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. The inspiring language of the Sweezy and Nickerson cases has become part of our national literature, but their hymns of praise to academic freedom were short on specifics. I found myself hungry to learn more, both about the scope and limits of this special concern of the First Amendment, and about what had been happening politically that gave rise to these cases, both the soaring rhetoric and the many defeats in the 1950s for civil liberties, and about what has happened since to academic freedom. So, on to part 2, which I call Harry, Vera, Felix, and Bill. It's always interesting to know something about the people whose names end up on Supreme Court cases. It turned out that the same Harry Nickerson, who was the namesake of Nickerson versus Board of Regents in 1967, was, 15 years before, a Queens College undergraduate when the Senate Internal Security Subcommittee, or the SIS as it was known, came to New York City to investigate suspected communist or other subversive elements in the educational system, and to pressure the board that ran the city's public colleges to fire anybody who was thought suspect or who did not cooperate. Like so many of the political investigations of this era, the SIS interrogations could go well beyond the proverbial $64,000 question about past or present Communist Party membership and could cover books and magazines the teachers read, meetings or concerts they attended, petitions they signed, funds they contributed to loyalist Spain or to support of refugees after the fascist victory in the Spanish Civil War, enrollment in the left liberal American Labor Party, and much more, many more questions of the same ilk. Now, a favorite professor of Harry's at Queens, the economist Vera Schlackman, was one of the first to be summoned by the SIS. Schlackman had sterling credentials, including a PhD from Columbia, and was the author of Economic History of a Factory Town, a groundbreaking book in the relatively new field of labor history. In her testimony, she objected that the investigations were making a mockery of political and intellectual freedom. But even before the famous case of the Hollywood 10, those directors and screenwriters who refused to cooperate with the House Un-American Activities Committee back in 1947 and went to jail for their defiance, the courts had rejected the First Amendment freedom of speech as a basis for resistance to politically driven legislative investigations. And so Schlackman cited the Fifth Amendment as well in explaining her refusal to answer. She, and in the ensuing months, more than a dozen other New York professors who resisted the SIS, were summarily fired. Vera was unemployed for a year, finally found work as a secretary, and was able to return to academia 8 years later, first at Adelphi, later at Columbia School of Social Work. Now, 8 years might not seem like all that much. Many victims of the academic heresy hunts were never able to return to their chosen profession. But it's difficult to measure the toll taken by these sorts of experiences on any individual. In addition to the stigma, the economic hardship, and the disappointed ambitions, there was the ever-present awareness of FBI surveillance. In Vera's case, she wrote some articles but never published another book. Yet, as one scholar has written, and I find the observation particularly meaningful, as a summary of the broader effects of the McCarthy era on intellectual life, quote, "In some sense, those of us who do labor history remain the intellectual children of Vera Schlackman, and those like her who belong to a generation stopped in its tracks." Our friend Harry Kayishian, meanwhile, an apolitical campus girl chaser, as he told me, before the firing of Professor Schlackman, joined a student protest committee. It was his first foray into politics. 10 years later, as we know, he became the lead plaintiff in the lawsuit that finally ended anti-subversive public employee loyalty programs. Few lawyers at the time thought that Harry and his 4 fellow plaintiffs at the University of Buffalo would succeed in striking down New York State's Feinberg Law, a sweeping but very typical Cold War-era loyalty measure that made, quote, treasonable or seditious utterances, distribution of materials advocating revolution, or membership in any of a list of allegedly subversive organizations grounds for firing teachers and professors at public schools and universities. But Harry did win. He called it his, quote, revenge on the 50s. Now, the personalities that populated the Supreme Court bench in these years were easily as colorful as the teachers and students whose lives were changed by the anti-communist purge. William O. Douglas, who wrote a series of prescient dissents from decisions in the early 50s that upheld virtually any loyalty oath, investigation, or politically driven criminal conviction that came before it, was famously antagonistic to Felix Frankfurter, whom he considered a pompous windbag. Frankfurter did tend to go on at the justices' conferences in long lectures to his brethren. After one such session, Douglas, no slouch when it came to controversy, circulated a memo calling Frankfurter's conduct, quote, insolent, a degradation of the conference and its deliberations. So much, I thought as I read it, for the myth of sweet collegiality among our judicial philosopher kings. Frankfurter's lectures often championed the virtues of judicial restraint, but I hadn't realized quite how frankly political his idea of judicial restraint was until I happened upon another memo in the Library of Congress archives from him to Justice Brennan regarding a First Amendment challenge by a left-leaning organization called the World Fellowship to a state attorney general's demand that it disclose various information about its employees and the identities of all its speakers and guests. Frankfurter's memo argued that, quote, the vast appropriations that the Congress votes every year to J. Edgar Hoover persuaded him to uphold the legitimacy of the investigation. I thought, hardly a model of dispassionate judicial analysis. There's much more in the book about Bill and Felix, as well as Justices Robert Jackson and Hugo Black and other members of the Vinson and Warren courts, and about the ways in which politics shapes jurisprudence. But on to part 3. What is academic freedom anyway, and what are its limits? Felix Frankfurter, incidentally, departed from his beloved judicial restraint when it came to academic freedom. He wrote a concurring opinion in the Sweezy case that would have straightforwardly invalidated the New Hampshire Attorney General's questions to Professor Sweezy on First Amendment academic freedom grounds. Chief Justice Warren's opinion for the court in Sweezy stopped short of a First Amendment ruling. Frankfurter's Sweezy concurrence articulated a view of academic freedom that has been debated ever since. He said the essence of the right of it is the right of a university, quote, to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study, end quote. But the Sweezy case turned on the rights not of the university, but of the professor, both in the classroom and in his so-called extramural activity, that is, activity, advocacy, and political association that's not part of the academic job, but takes place, whether literally or figuratively, outside the university's walls. So, does First Amendment academic freedom, in fact, belong to individual teachers, to the university as an institution, or both? Frankfurter may not have seen any conflict, but there has been plenty of conflict since. The Supreme Court has since recognized that First Amendment academic freedom protects both the teacher and the institution, but it didn't explain what happens when these rights collide. For example, when someone denied tenure at a public university claims that the decision violated her academic freedom, but the administration responds that it has a near absolute right to decide who shall teach and what shall be taught. I say public university here because, as many of you know, the First Amendment does not restrict the actions of private employers. Courts almost always defer to universities in tenure cases, and surely it's right that the school gets to decide many questions about teaching and scholarship. For example, what courses will be in the curriculum, and whether scholarly work is of sufficiently high quality to merit hiring, promotion, and that rapidly disappearing commodity, tenure. But academic freedom is fundamentally about the individual teacher. As Frankfurter himself wrote in an early loyalty oath case, and I use this metaphor for the title of my book, teachers are, or at least are supposed to be, quote, the priests of our democracy, because they foster those habits of open-mindedness and critical inquiry, which alone make for responsible citizens. The idea is that academic freedom, which seems at first an elitist right that belongs only to pointy-headed intellectuals, is in fact essential to democracy. Or, as Justice Brennan put it in Kayishian, academic freedom is, quote, of transcendent value to all of us, and not merely the teachers concerned. Felix Frankfurter may not have perceived any conflict between individual and institutional academic freedom. Like the American Association of University Professors, the AAUP, whose 1915 Declaration of Principles on Academic Freedom and Tenure described the university as a community of scholars who should be able to make educational decisions without interference by those Philistines as they saw it on boards of trustees. Frankfurter was expressing an idealized notion of education conducted by priest-like scholars who would collectively decide, quote, who may teach, what may be taught, how it shall be taught, and who may be admitted to study. He probably did not foresee today's highly bureaucratized university, with its layers upon layers of provosts and sub-provosts and vice-provosts and deans and sub-deans and vice-deans, and its armies of contingent faculty who have no voice in governance. At some point, we may get further elucidation from the Supreme Court on the proper balance between institutional and individual academic freedom, if indeed the current court will even recognize that individual academic freedom still exists. Why is this long-held verity of constitutional law now in doubt? The explanation requires a short, but I hope not too convoluted digression, in the course of which we'll get an answer to that question of why a U.S. Court of Appeals denied any First Amendment protection in the case I mentioned about half an hour ago, involving those Virginia professors who wanted to access sexually explicit content on their office computers. This country's early controversies over academic freedom, which I recount in the first chapter of Priests of Our Democracy, involved retaliation against professors whose outside political activity, that is, their extramural speech, was not to the liking of boards of trustees. So it was not surprising that when, in 1915, the AAUP was formed, its founding Declaration of Principles identified three parts to academic freedom: not only classroom teaching and scholarly research, but also extramural speech. Likewise, the Supreme Court's recognition of academic freedom in Sweezy and Kayishian was mostly about extramural speech, a response to the immense political pressures of the McCarthy era to deprive people who were often wonderful teachers and scholars of their jobs because of their political beliefs and associations, that is, their extramural speech. As Kayishian versus Board of Regents established, they should not have had to relinquish their First Amendment rights to speech and association as a condition of employment. But why was this specifically a question of academic freedom and not the First Amendment rights of all public employees? The answer is an accident of legal history. It was not until a year after Kayishian, in 1968, that the Supreme Court got around to extending First Amendment protection to all public employees, or at least a measure of First Amendment protection. The court said they couldn't be punished for speech as citizens on matters of public concern, unless their expression could be shown to interfere with workplace efficiency. The case was called Pickering versus Board of Education, and ever since, Some commentators have argued that there's no longer a need for the extramural speech prong of academic freedom. That is, teachers at public universities have the same and no greater First Amendment rights than other public employees. And subjecting teachers to the same Pickering balancing test as everyone else in public employment would do much to combat charges of elitism and special pleading, and thus make courts and the public more hospitable to core academic freedom claims involving teaching and scholarship that are intrinsic parts of the academic job. This makes sense to me with the following caveat. A university is a quintessential marketplace of ideas. It would therefore contradict the very function of a university to punish a professor for extramural speech on the ground that it interferes with workplace efficiency. That's the balancing test of Pickering. That is to say, free inquiry and dissent, not uniformity and political orthodoxy, are the essential components of a healthy and efficient academic workplace. A university that allows free expression is efficient, one that stifles it does not. Certainly then, complaints from trustees or indignant alumni about a maverick professor's extramural speech, including threats to withhold donations, should not be grounds for concluding that the professor's speech interferes with workplace efficiency. In that sense, academic freedom, the essence of higher education, feeds into the First Amendment balancing test that applies to all public employment. And to the extent academic freedom is a matter of good educational policy, not just law, the same considerations should apply to private institutions of higher learning. I leave for another day the question of whether and how academic freedom should protect teachers in K-12 education. I wouldn't want the current Supreme Court to get anywhere close to that one. Now, somewhere along the line, I hope you're still with me, the Pickering balancing test fragmented. The Supreme Court began to view speech on the job, complaints about the boss's management style, for example, not to involve matters of public concern and therefore to have no First Amendment protection. Sometimes it's true, internal job-related complaints are not of great public concern. But in other cases, whistleblowing being the most prominent example, they are of immense public concern. The court's increasingly rigid distinction between job-related speech by a public employee, which it says has no First Amendment protection, and speech of public concern contributed as a citizen, which it says enjoys limited protection under this balancing test, has led to some bizarre results. It certainly accounts for the controversial Court of Appeals ruling in that case involving the Virginia professor. In the latest round of its increasingly radical shrinkage of public employee rights, the Supreme Court in a 2006 case called Garcetti versus Sabalos denied any First Amendment protection to an assistant prosecutor who informed his superiors about fraudulent statements in an affidavit for a search warrant, and after his boss refused to do anything about it, testified to this effect in connection with a defense motion challenging the warrant. He was punished with reassignment, transfer, and denial of a promotion. But the Supreme Court dismissed his claim that the retaliation violated his First Amendment rights. Quote, "When public employees make statements pursuant to their official duties," Justice Anthony Kennedy wrote for the court, "the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline." End quote. Now, the notion that there is no First Amendment protection for an employee blowing the whistle on fraud in the prosecutor's office is shocking enough. But what are the implications for academic freedom? In response to an alarmed dissent from Justice Souter, pointing out that professors' classroom teaching and scholarly research are also done pursuant to their official duties, Justice Kennedy added a caveat to his opinion in Garcetti. He wrote, quote, there is some argument that expression related to academic scholarship and classroom instruction implicates additional constitutional interests that are not fully accounted for by this court's customary employee speech jurisprudence. We need not, and for that reason, do not decide whether the analysis we conduct today would apply in the same manner to a case involving speech related to teaching or scholarship. As I remarked in Priests, the court's once full-bodied appreciation of academic freedom as a special concern of the First Amendment was now reduced to an ambiguous aside. At last, part 4. Finally, here is the first of my 3 not-so-hypothetical situations that I promised you. Earlier this year, the Freedom from Religion Foundation accused a physics professor at a Midwestern state university of teaching a course in religious indoctrination, not science. Indeed, his syllabus was replete with creationist texts. Arguments were made that academic freedom protected both the topic of the course and the choice of the assigned readings. So putting aside for a minute the problem of church-state separation, the foundation argued that offering the course at all at a state university violated the First Amendment Establishment Clause. I think that's a close and difficult question. It seemed to me that the academic freedom argument was misplaced. Certainly the freedom to teach does not include the right to offer a course that the institution, informed hopefully by faculty experts and department heads, does not think amounts to good science. The controversy wasn't about the choice of particular readings or the conduct of a class discussion, but about the presence or absence of scientific foundation for the entire course. So, a limit, I would argue, to academic freedom in the realm of classroom teaching. But what if the chair of the physics department or the university's curriculum committee decides that a course in creationism masquerading as science is just fine? Reasonable scholars, we hope, won't make these mistakes, but whatever may be the difficulty of drawing lines when it comes to classroom teaching or reading assignments, I would maintain that the institution's academic freedom trumps the individual's when it's a question of offering a course at all. My second example involves not classroom teaching, but scholarship, and many of you will remember this one. Former DePaul University professor Norman Finkelstein's scholarly writings criticize what he calls the Holocaust industry and argue that Israel uses the Nazi genocide as a justification for all manner of objectionable policies today. In 2007, when Finkelstein was up for tenure, Harvard law professor Alan Dershowitz attacked him in a letter that he distributed to the DePaul faculty, and he lobbied hard for the university to reject the tenure application. Dershowitz prevailed, despite favorable votes from Finkelstein's Department of Political Science and the College of Arts and Sciences Personnel Committee. The New York Times described Dershowitz's campaign as a full-court press. Finkelstein called the tenure denial transparently political and an egregious violation of academic freedom. Finkelstein later reached a settlement with the university in which it acknowledged that he was, quote, a prolific scholar and outstanding teacher, end quote. Would he and should he have won a First Amendment case if DePaul had been a public university? Although courts will, as I've noted, give broad deference to the judgments that go into tenure decisions, this may have been the rare case where a court should have found the decision was improperly based on the controversial nature and not the quality of Finkelstein's scholarship. I come to my third example, and probably the most incendiary of the 3. Professor Ward Churchill of the University of Colorado wrote an article after September 11th, 2001, in which he attacked the stock traders who worked at brokerage firms in the World Trade Center as, quote, little Eichmanns, because, he said, they were part of a technocratic core at the very heart of America's global financial empire and were thus complicit in the suffering and loss of life caused by American military operations. The university, not surprisingly, was besieged with outraged demands for Churchill's firing. It set up a committee to investigate him. The committee found some instances of what it called, quote, research misconduct, faulty footnoting and the like, and recommended his dismissal. Churchill brought suit. A jury quite rightly concluded that research misconduct was an obvious pretext for firing Churchill because of his toxic remark about little Eichmanns. But the trial judge decided he should lose his case anyway, because the committee that recommended his firing was entitled to quasi-judicial immunity from suit. The Colorado Supreme Court affirmed this bizarre ruling, which basically would mean you could never sue a university for any kind of academic freedom violation if it set up a committee to recommend that you be fired. Colorado Supreme Court affirmed this bizarre ruling, which goes to show that really annoying plaintiffs can make really bad law, and that courts remain vulnerable to political pressures, now as in the days of the anti-communist purge. Should there be an exception to the First Amendment protection for extramural speech like Churchill's when it's sufficiently outrageous to the majority of the community? I don't think so. One of the trial judge's alternative theories in Churchill's case was that even if he hadn't overturned the jury's verdict on grounds of quasi-judicial immunity, he would not have ordered the university to reinstate Churchill because the campus atmosphere was poisoned. Too many people did not like him. But free speech is naturally contentious, and using majority animosity to justify disqualification from employment amounts to allowing a heckler's veto. I hope we haven't yet reached the point where not doing lunch well is a disqualification from an academic job. Now, some of you may disagree with my analysis of any of these three not-so-hypothetical hypotheticals, and may draw the line differently between academic freedom for individual teachers and university control of curriculum, scholarship, or extramural speech. I welcome that disagreement. It's the stuff of free speech, after all. Conclusion. One final thought. When the AAUP first articulated the now commonly accepted three-part definition of academic freedom, teaching, research, extramural speech, in 1915, it linked the concept inextricably to tenure, without which, its founders thought, professors would not have the job security needed for them to speak freely without fear of reprisal. Today, tenure is dramatically shrinking. Tenure-track jobs are getting as rare as fish on bicycles, and contingent faculty make up about 75% of undergraduate teaching ranks. As one journalist put it, an army of adjuncts are now, quote, the hamburger flippers of the academic world, unquote. Academic freedom in this environment has to be divorced from tenure and understood as the essence of higher education for everyone involved. Adjuncts, non-tenure track instructors, graduate students, and yes, even those sometimes unruly undergraduates. As I hope I've made clear, academic freedom is by no means an absolute right, and its limits can be murky. But preserving it and retooling it to meet the needs of today are more important than ever. I think Davis, Markert, and Nickerson would agree. Thank you. Should I stay here?
As far as the Supreme Court is concerned, when they decide on the constitutionality of certain issues, how come there is a split like 5-4, 6-3? It should be 9-0 or 0-9.
Why do they split?
Yes, it's like being you can be either pregnant or not pregnant.
Very good question. And if the 9 justices of the Supreme Court were really the Platonic guardians that maybe exist in American myth, there would be one answer. You apply the First Amendment or whatever provision of law or constitution is involved to the facts of the case, and all right-thinking, smart, analytical judges would agree with the same result, but it doesn't work that way, especially with constitutional law. It goes without saying that judges are people, and they come to the courts with a whole set of political, cultural, religious, ethical ideas and biases, and presidents appoint judges that they think will promote their particular ideas. And in the area of constitutional law especially, I talked about the Pickering balancing test. There are many balancing tests. Almost all of constitutional law is a balancing test. Hugo Black used to say, the First Amendment says Congress shall make no law abridging the freedom of speech. But clearly there are many exceptions to the First Amendment, and no law does not, in fact, mean no law. So there's a balancing test for all of these Delphic phrases in the Constitution. What does the freedom of speech mean? What does equal protection of the laws mean? What does due process of law mean? And how do you weigh the values, the interests on either side of the balance? Depends on your politics, your background, your culture. So there used to be more unanimous decisions than there are now. There are almost none now.
Thank you for that wonderful presentation.
Thank you.
It was really, really delightful to look back a little bit. I teach the higher ed law class here, so I'm familiar with a lot of these cases, and it really is fun to hear your perspective after having done so much research on it, on them. I'm thinking about your comments about Garcetti, where the Supreme Court paused in making a decision about whether or not academic freedom would be subsumed within the Garcetti rule. And so they've created this moment for us to explore about whether or not we will curtail teachers in the way we curtail other kinds of employees. And courts have been coming out in different directions. You mentioned the Urofsky case, the Virginia case involving pornography on computers or sexually explicit materials on computers. And that was the Fourth Circuit. And recently, the Fourth Circuit decided the Demers case, in which, despite having previously said that individual faculty members have no independent First Amendment academic freedom rights, we now see the same circuit saying, actually, maybe they do. And I was wondering if you'd comment on the dramatic change in the Fourth Circuit.
Yeah, that was actually Adams. So, yeah, post-Garcetti, the lower courts have been all over the place on this. And a lot of it depends on what faculty speech is involved. And the first couple of cases that came up had to do with what some of us would call governance, but what others and some of the judges who heard these cases would call petty disputes about administrative matters. So a couple of cases in which professors claimed they were retaliated against for criticizing various aspects of administrative governance, and they lost their First Amendment claims that the retaliation violated the First Amendment because the court said Garcetti says this is just job-related speech and you have no protection against punishment if you get the boss mad. But the Adams case, which you mentioned, and the most recent case, Demers, out of the Ninth Circuit, well, Adams had to do more with core, not exactly scholarship, but his writing and his research, and his and to some extent his political viewpoints. So the different, I mean, part of the reason there are two, I'm not sure you can reconcile the Fourth Circuit decision in that Urofsky case involving, you said pornography, it was broader than that, but obviously that's what the legislature had in mind, with the later decision in Adams, which involved a different set of facts, didn't have to do with sex on the internet, and maybe different judges. Demers was a little closer to a kind of governance issue, because here is a professor, I believe in journalism, who's criticizing various aspects of the administration of the journalism school at his university. And if I'm remembering right, he'll correct me, the lower court said Garcetti rules and he has no claim. Goes up to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals says Garcetti leaves open this question, and we think this is core academic freedom. He is participating in the governance of the university, and the rule of Garcetti does not apply in that context. So somebody I was talking about this with the other day said, well, the Supreme Court will be answering this question soon. And my response is, I sort of hope not, because at best I think we'd get we'd get some limitations on the very broad language of the Keishian case, and kind of much more limited scope for individual academic freedom. And one thing that the court in that Urofsky case involving the sex on the computers said was, if academic freedom exists at all as a First Amendment matter, it belongs to the institution and not to the individual. And that might very well be where the current Supreme Court goes. But as I mentioned in answer to the first question, Supreme Court majorities change. And not only because there's new personnel on the Supreme Court, but because people on the Supreme Court change their mind. So somebody like Kennedy, who wrote the opinion in Garcetti and clearly did not have any sympathy with this whistleblower prosecutor, might have much more sympathy with an individual professor. It depends on, if it were Churchill, probably not. If it's some other professor with more sympathetic facts, maybe.
The U.S. Constitution has probably the broadest view of freedom of speech of any Western democracy. Is there any value in looking at how other democracies treat academic freedom?
I think so. Yeah, that's a very good question. I think it's an open question whether the First Amendment protection for academic freedom is really the broadest in the world. I mean, it sort of depends on what subject matter you're looking at. If you're looking at obscenity law, for example, we have more restrictions than other countries. So the fact, as I mentioned, that the First Amendment says no law has never meant no law. And we have numerous exceptions to the First Amendment, obscenity being one of the big ones. The Supreme Court says in a case in 1942, there are certain categories of speech which are no part of the essential exposition of ideas, such as obscenity, fighting words, libel. And so that gets no First Amendment protection. Well, where did that come from? First Amendment doesn't say anything about the exposition of ideas, and in subsequent cases, the Supreme Court has frequently said entertainment is entitled to First Amendment protection. It doesn't have to be about the exposition of ideas. But that kind of broad statement that the First Amendment doesn't protect everything, and courts can make value judgments, continues to drive obscenity law today. So we have courts, juries, police, prosecutors getting into the business of deciding whether to cite one case that may be in some of your memories, the Cincinnati Museum of Contemporary Art violated obscenity laws when it showed the works of Robert Mapplethorpe, or did they have enough value to be protected by the First Amendment? So other societies would not get into those kind of dilemmas, even though they may not have a First Amendment in their constitution.
Great talk. Toward the end of your remark, you refer to the Norman Finkelstein case. Though you didn't really get into the reasons for the controversy about his scholarship, which is that it was extremely critical of the Israeli state and of Zionism. This seems to me to be one of the big issues, independent of that case around the country, where people who are critical of the Israeli state are accused of being anti-Semitic, and then there's a campaign to punish them in some way. At the same time, a number of the targets of the criticism are also demanding a boycott, an academic and cultural boycott, not just an economic boycott, but academic and cultural boycott of the State of Israel, have even approached AAUP and other academic groups to endorse this. What's your take on that whole controversy, and how does it relate to academic freedom in the U.S.?
It turns out, without intending to, I've ended up in the middle of this controversy because the AAUP has an online journal of academic freedom, which decided to devote most of an issue to the question of the call for an academic boycott. And the AAUP has long opposed academic boycotts of academic institutions, not opposed general economic boycott. So I contributed to this debate in this current issue of the journal, and I basically laid out the arguments for boycotts in terms of they're an important expression of First Amendment rights and people coming together, and there are precedents for the civil rights movement about how boycotts are protected by the First Amendment. But on the other hand, they also have significant censorship effects on those who are the targets if the boycott is directed against universities and scholars. So I said, probably on balance, at least until somebody could show that Israeli universities are not universities as we understand them anymore, that they have no academic freedom themselves, no dissent, an academic boycott's probably not the way to go. It turned out everybody else who contributed to this issue of this online journal argued the opposite, argued in favor of the AAUP changing its position and joining in an academic boycott. Oh, okay. This was not an accident. Yeah, I mean, I think that's right. And I was just saying to a student, I recently read a book called The Third Reich and the Ivory Tower. And it's really quite an eye-opener because it documents how between 1933, when Hitler came to power, and about 1938, the most prestigious universities and colleges in the country, the Ivy League universities and the Seven Sisters colleges, continued to have, did not boycott the Nazi universities, continued to have exchanges to invite Nazi diplomats and scholars long after the German universities had ceased to be universities that had any kind of political independence or academic freedom, or obviously any Jewish professors or any dissenting professors. That's a situation where an academic boycott might be appropriate because there's really nothing left. That's not the situation in Israel. So I would continue to maintain that it's probably not a great idea, although certainly people have a First Amendment right to do it as a way of expressing opposition. Thank you.
The University of Michigan Senate's annual Davis Markert Nickerson Lecture on Academic and Intellectual Freedom is supported in part by contributions by the public to the Academic Freedom Lecture Fund and might qualify for both Michigan as well as federal income tax deductions. If you wish to contribute to the fund, checks should be made payable to AFLF and mailed to Post Office Box 4152, Ann Arbor, Michigan 48106-4152. Alternatively, checks may be made payable to the University of Michigan AFLF and mailed to the same address. These latter contributions will be invested in a University of Michigan account entitled Academic Freedom Lecture Fund, which is under the joint stewardship of both the University of Michigan Senate Advisory Committee on University Affairs and the Board of Directors of the Academic Freedom Lecture Fund. Individuals who contribute become members of the Academic Freedom Lecture Fund and will receive information about activities sponsored by the fund. The Academic Freedom Lecture Fund is a Section 501c3 nonprofit organization. All contributions to it are tax-deductible under IRS regulations.